Well, welcome everyone. Welcome to the Tribal Law and Policy Institute webinar presentation of the fiscal year 2019 funding opportunity for tribal healing to wellness courts, the BJA Adult Drug Court Solicitation. Just a friendly reminder that the conference line will be muted throughout the webinar. However, we warmly welcome you to ask any questions as they arise. We will certainly be able to address each and every question at the end of the webinar, but time permitting, we will attempt to address them as they arise during the course of the webinar. This webinar will be recorded. A recording will be posted onto our website at wellnesscourts.org, where you can also find recordings from our past webinars. In addition, we'll be posting a PDF of this slide deck, but you can access this slide deck right now. It's one of the two handouts that you'll see on the right-hand column. You can click on that and follow along if you'd like, or print it out for your colleagues. You'll also find attached a PDF of the solicitation. This is the exact same solicitation that you can find online, but I posted it here just for your convenience. So welcome. My name is Lauren Van Schilfgaard. I am the Tribal Law Specialist with the Tribal Law and Policy Institute, and I am very honored to be joined by Gregory Terrain, who is a policy advisor with the Bureau of Justice Assistance and the manager for this very grant. So if you have questions regarding this solicitation, this is an excellent opportunity to ask literally the expert in the room. Greg, would you like to say hi?
Yeah, hi everyone, and welcome to this year's FY 2019 solicitation for the Adult Drug Court program. Really excited to have you all on today. Last year, I know Lauren had mentioned that we made a record number of awards. We received a lot of tribal applications for tribal healing to wellness courts, and we made a lot of awards, and we're looking to do the same this year. So I encourage you to definitely apply, ask questions, and I look forward to your application coming through. All right, thanks, Lauren.
Thank you, Greg. I am going to attempt, here we go. Let's see, I just want to make sure that everyone's able to call in okay. Let's see, I'm going to post in our questions box another invitation to the webinar. So in case people are having trouble calling in, you should hopefully be able to see it. Oh, thanks so much for doing that. Hopefully you're able to hear okay. If you're not hearing this okay, or it appears to be scrambled, try turning off your computer speakers, or vice versa. Try hanging up the phone. You might be getting two audios at the same time. All right, here we go. So on this webinar, we are going to be addressing specifically the BJA Adult Drug Court Solicitation. This is a major funding source for healing to wellness courts, a really great one for tribes, so that's why we're devoting an entire webinar to it. However, at the end, we'll also be discussing some grant writing tips generally that's going to be definitely relevant for this solicitation, but also for some other solicitations that are out there. I'll be discussing some that have already passed, as well as ones that I anticipate to be posted in the future, but I want to put them all on your radar so that you know what's out there. One moment. Okay. So where do you find this RFP? It's pretty easy. I have had lots of luck. If I Google BJA and drug court, it pops right up. You'll see this bja.gov. We've also posted it on our website at wellnesscourts.org. You can't really see it on this. I apologize for that. But here we have funding announcements, and that's where I posted it here. But like I said, a simple Google search should get you there, and it's also as a handout right here. Oh no. I locked myself out. There we go. So what's in the solicitation? There's two different categories. There's actually three different categories, but one is specifically for states. So I won't be highlighting it here just because this webinar is intended for tribes, but it's there so that you know it's there. So implementation, maximum for $500,000 for 48 months or 4 years. Greg, could you comment on what this maximum allocation of money and how it relates to years in the past?
Okay. In the previous years, the implementation grant was at one time it was $300,000. Within the last 2 years, we did increase it to $500,000, and this is over a 48-month period, which is 4 years. And we pretty much did that for a number of reasons. We wanted to make sure that once you be able to apply for this funding, that you're able to have enough funds to be able to support it. We also reached out to the field and got recommendations in terms of was the initial amount that we had in past years was enough to get the job done or be able to implement a drug court. So we had made the increase along with also the budget over the last 2 years for drug courts or for the adult drug court discretionary grant program has increased from $50 million to $99 million. So we've allowed support for drug courts in moving forward, and we've been able to increase the number of awards that we have been able to make. And we're really excited about having that additional funding to support more site-based awards, which will be the individual drug court or tribal illness wellness court programs. And just to also add to that, when you compare the implementation to enhancement, implementation grants are for those drug courts or tribal illness wellness courts that are looking to start a new tribal illness wellness court, whereas enhancement is for those that are looking to enhance a already established tribal illness and wellness court.
Oh, thank you, Greg. I'm having silly computer troubles, which is great for this webinar, but hopefully you can see it just fine without this slideshow mode. So moving right along, I'm going to walk through what's in the solicitation just to highlight they have some really specific language that I think is focusing in on. Whether or not it's going to make it into your grant writing, that may or may not be the case, but I definitely want to highlight it. So they identify what they see as an effective drug court, and it's a pretty specific definition. It's to reduce recidivism and substance abuse, right? That's our common understanding of what a wellness court is, that it's not enough just to reduce the criminal justice component, and it's not enough just to help participants into recovery. We want to see performance measures from both, right? Specifically among high-risk participants through referrals based on validated assessments, early and continuous and intense treatment, close judicial supervision, mandatory and random drug testing, community supervision, equitable, consistent, and appropriate incentives and sanctions, and community reintegration and recovery support. Now, apologies, Greg, I'm going to put you on under the spotlight again, but I'm really curious. I really like this definition, but it makes me scratch my head a little bit because it's not in reference to the key components. It's 7 identified features. So I wonder if there's obviously a relationship, but not a one-to-one relationship. So I wonder how we should be looking at this definition, or is it purely just a supplemental guide in addition to the key components?
They're a supplemental guide to the 10 key components. It really, and some of these things are a part of the 10 key components as it relates to ensuring that you make sure you use a validated risk assessment tool, ongoing supervision, judicial supervision, mandatory drug testing. Those are specific components of the best practice standards. But some of the other ones are related to what we also found based off evidence-based that will make a drug court or tribal illness wellness court successful.
Okay, thank you. That was always a little confusing for me, so I appreciate it.
Yep, no problem.
Okay, so they also have another definition of what is a drug court. It is a court program managed by a multidisciplinary team that responds to the offenses and treatment needs of participants who are diagnosed with substance abuse. The underline are my doing. These are things that I wanted to highlight for you. So I think this is all to say that the Bureau of Justice Assistance opens this solicitation up to the whole country, right? They're targeting states, they're targeting urban cities, municipalities, they're targeting counties, rural jurisdictions, and they're also targeting tribes. These are all incredibly diverse and varied institutions that have very different bureaucracies that approach a problem-solving court. Nevertheless, they want each of those to sort of fit into this understanding of what's a drug court. However, I also see a lot of flexibility that as long as it's a court program, pretty diverse, multidisciplinary team, lots of different people can be on there, there's lots of flexibility to still express our own sovereignty, our own understanding of what a healing to wellness court can and should be. And so just want you to keep that in mind, that this is a definition, but there's still a lot of room for you to make it your own. So BJA has also identified their own objectives. These are the reasons behind why they're building the solicitation. Utilize evidence, evidence-based practices. We'll be talking about this a little bit later. There's certainly a huge emphasis on this for us, but there's also a recognition that many, if not all, of the evidence-based practices that are currently widely accepted, particularly by SAMHSA, have not been studied within Native communities. But there's a lot of exciting work around tribal adaptations of some of these programs, as well as the recognition that tribes can pursue some practice-based evidence programs that they know are best for their own communities. Build capacity. This green one, this is big for us. I would say this is the primary BJA objective, if there was one. They want every single grantee to be thinking about how they're going to increase the number of participants served with these dollars. Expand targeted evidence-based services, which are specific, not just practices from the NADCP standards, but specific services. Recovery support services. This is, I think, a little bit new. It's always been there. I think part of our key components, right, is we want to help our participants once they graduate and go out on a good road. However, I've seen an increase in the emphasis that no, we need to be doing some much more targeted and specific efforts around how we're going to be setting up our participants for success, both within the wellness court as well as after the wellness court. So as we'll see in what ideas that BJA has for how you can use this money, there's a big emphasis on recovery support services. Ooh, I like this orange one. Reduce obstacles to successful recovery, and they specifically call out civil legal assistance as an opportunity where you could spend these funds. I haven't seen that before, and I think that's incredibly interesting. And finally, support data collection and analysis. This has always been a priority for BJA, but it's shifted a little bit, and I think there's a much bigger call for tribes, not just in this meta sense that you should be contacting a very expensive, private consultant who's going to come and do this very comprehensive evaluation. No, you should be considering that and prioritizing that, but on a day-to-day basis, what is your wellness court doing to capture its story and better tell its story, whether it's to the funders like BJA or to the community, to your participants, to your judiciary? How are you tracking what's happening in your wellness court? So let's get into the meat of the application. Who is eligible? They call out these various different courts, which has expanded over time, which has been really interesting. We have your adult drug courts, as the title of the solicitation indicates, DUI courts, co-occurring courts. These are also known as mental health courts. Co-occurring is a reference to serving individuals who have both a substance use disorder as well as a mental health disorder. And as many of us know, it is best to treat that individual with both of those diagnoses simultaneously rather than chronologically or consecutively or not at all. So that's what those courts are. Many of us are doing this work already in our Healing to Wellness court, but in some jurisdictions, especially urban, the caseload is so extensive that they've found it useful to create their own docket for these special co-occurring courts. Veterans treatment courts, this also appeared in last year's solicitation. Just, little asterisk here, there is lots of opportunities within the veterans treatment court world. There's lots of funding, and as we'll see, there's also some extra opportunities with here. Now, what's interesting is that tribal healing to wellness courts have a special call out. As many of you, I think, have quickly recognized, this is sort of an apples and oranges characteristic, right? Adults, veterans, everything in between, those are types of different problem-solving courts. A tribe is a different jurisdiction. A tribe can exercise all of these different courts. So while you will all be applying as a tribal healing to wellness court, you additionally need to identify what type of drug court within these the first four categories will you be applying as. Okay, so implementation, we noted that this was for $500,000, which, as Greg said, is a huge increase, incredible. Now, this is for implementation, tribes that are not yet operational. However, they do distinguish between not operational and haven't even started planning yet. They want tribes that are ready to implement. AKA you receive the funding and you can start operations, start serving participants, the next month. You're ready to go. You have your team identified. You have most of your primary documents drafted. You have a pretty good conception of what your wellness court is going to look like. Now, don't panic if you're not quite there. In putting the solicitation together, you'll certainly have to identify a lot of the structure that you anticipate is going to be in place for your wellness court, but these funding decisions aren't going to be made until likely September 30th. The grant year for you, should you be successfully awarded, will begin October 1st of 2019. So there's some time between then and now to start really tackling a lot of the planning to-do items. However, you still need to have a good idea of what's happening because you need to be able to put it down into solicitation. So as I noted,
and Lauren,
yes.
Hey, Lauren, this is Rick. What I want to add, probably the funding decisions will probably be made more like it toward the middle of summer, looking at around July and August.
Really?
The good thing is when you're looking to apply, ensure that, if you include what are the things that you've done in terms of planning and what are you continuing to do in terms of planning for your implementation, part of the grant if you apply for implementation.
Okay. So it's a little bit closer. Will the fiscal year still be October 1st when your grant period will start?
Yeah, well, we have it in the solicitation. I believe we have between, let me look real quick. I think it's between September to January. So we gave an in-between dates when we're going to start. And this year is going to be a little different from last year. I think last year we had pretty much a late start last year. We're starting a little bit earlier than we did from last year. So we're looking to make those decisions a little bit earlier than we did last year.
Okay, well, awesome. Great news for earlier is always better. Little tough on the planning end, but nevertheless, yeah, it sounds like it'll still be, fall time, which is usually when they are.
Yeah.
So, and you can see in our what can you use the funding for, there's a pretty broad categories, it's pretty open for what you want to do. There's no, because it's the nature of a healing to wellness court is this multidisciplinary team, every single tribe has a different need. For many, it's funding the coordinator position. This is a position that usually isn't captured by another agency, such as the judge or the prosecutor or the treatment provider, which has their own agency and really just has to bring their time. But for many, it's not the coordinator. It could be a case manager. It could be the judge. It could be another team member or a combination of team members. Frequently, drug testing kits are a requested funding item, but those are very like mainstream budget items. There's a lot of opportunity to get creative, including for services that you might not be offer right now that you want to bring as part of the Healing to Wellness Court, as well as, I noted, these recovery support services. They know you could spend up to 25% of your grant on things like education for your participants, civil legal assistance. Note that this is an adult criminal court, so this would be providing legal assistance for participants' other legal cases going on. Job training, housing placement. I know one Healing to Wellness court that requested from this grant funding to provide rent payments for their participants in an apartment building that the Healing to Wellness court managed. And so they were able to provide immediate supportive housing for their wellness court participants. Primary and behavioral health care, pretty standard. Child care. I mean, it's incredible the variety that can go on here. Enhancement. So this is for Healing to Wellness courts that are in operation. They request that you be in operation for at least 1 year. So you can be pretty new, but you could also have been in operation for 10 years. This is open to you. One of the mandatory components of this enhancement portion of the solicitation is that you need to scale up the capacity. You need to note how many participants are you serving today, and to what number are you going to increase that number using the funding dollars from this solicitation. But from there, whatever direction you want to move in is up to you. Enhancing your court operations, enhancing your services, enhancing just the quality of the services, or being able to better monitor the fidelity of those services. It's up to you. As we'll note later on in how to structure your solicitation, it's important here, because you're starting from an existing court, that you draw a connection between sort of your problem statement, how are you operating right now, and where do you identify the deficiencies, and then what you're proposing to do. If you note that, well, we have a really low participant caseload and we have pretty limited services for our participants, but then your proposed funding is to provide housing, well, there's no connection there. So you want to make sure that where you're identifying your deficiencies mirrors where you're proposing your enhancements. So why should we bother with the solicitation? One of the tricky things about this is it's not specific to tribes. This is open to everyone, which means you're competing with everyone. But it is open to tribes, and I think especially in the last couple of years, BJA has made a concerted effort to ensure that tribes get an equal bite at the apple. And we most prominently saw this last year. Last year, more tribes than ever were awarded with 9 awards, which is incredible. I think that this is also indicative that this is a really ripe time to be prioritizing the solicitation. It also happens to be good timing. For those of you that are on this webinar, I'm frankly shocked because you should all be finishing up your CTAS applications. But it means that there is going to be no overlap, or very little overlap, between the CTAS and this solicitation coming out. I also think that this solicitation is much easier to put together than CTAS. So for those of you that are finishing CTAS and can't bear the thought of putting together another grant, I'm extremely sympathetic, but I do think this one's a little bit easier. I noticed two of our questions. One is asking about whether the acts of violence are defined. It is. We'll be getting to that in a later slide. And yes, this PowerPoint will be available after the webinar. It's also available right now in our little handouts panel. So if you click on the handouts, you'll see that this slide deck has been turned into a PDF, and so you can follow along there. So within the solicitation, BJA has identified a couple priority areas. One is participation in the Adult Drug Court Planning Initiative. This is an intensive 3-day training that the National Drug Court Institute offers. I think they've technically closed their applications. However, if you are very, very interested, feel free to email me at wellnesscourts@tlpi.org. You can put a question in the question box. They've been pretty flexible about trying to squeeze tribes in that are interested. However, like the solicitation, you need to kind of already be set up with how you're going to structure your wellness court. Primarily, do you know who your team is? Have you identified all of those key people? And can they all devote 3 days out of their incredibly busy schedule to participate in this training? It's a great training. It is truly the nuts and bolts of a healing to wellness court planning. And so I can see why it would be a priority area, because you will be very much set up for success with participating in that. However, if for some reason they aren't able to squeeze you in, we as a technical assistance provider as well, TLPI, can also provide the sort of planning nuts and bolts type of training. So if you're interested at all, just let us know. We can find something that will work for you in your court. Other priority considerations. Identify the specific NADCP standards that will be implemented. We'll talk about this in just a few slides. This is critical. So this is a publication that came out in 2013 and 2014, and it identifies a lot of those key components for which research has proven are, in fact, effective and critical for a healing to wellness court or a drug court. So we'll talk about those in just a minute. Rural and tribal jurisdictions have a priority consideration. Look at that, tribes. Wink, wink, nudge, nudge. That's us. They note this throughout the solicitation, that applicants must demonstrate that their treatment and services will be addressing opioid abuse reduction. This is because A, there's an opioid crisis going on. B, a lot of this funding streams came from a congressional package targeted towards opioid abuse reduction. Now, opioids might be a very serious drug in your community, whether it's the misuse of prescriptions or it's illegal substances such as heroin. Opioids might not be a priority issue in your community. It might be there, but it pales in comparison to methamphetamines or alcohol. That's okay. What they really want to see here is that you have treatments and services just in case. And so even though opioids might not be there, you're set up just in case they ever will be. So that's really what they want you to see here, that just it's on your radar. As I mentioned, here's the NADCP.org standards. You can go to this URL and find these 2 drug court standards. There's 2 volumes. These are the different categories that are addressed in each volume. It's a little bit of a tough read, cover to cover. Don't necessarily recommend that. However, I have found these 2 standards to be really useful when I had a specific question. When I wanted to know how much should we be drug testing our participants? Boom, you turn to volume 2, drug and alcohol testing, and they lay out the research indicating that at least 2 times a week participants should be drug tested. really interesting. Lots of drug courts were tapering down their drug testing frequency as a participant progressed through the phases, much like they would taper down the frequency with which you'd have a court hearing or your community service hours. However, the research indicated that while most tapering down was just fine, when it came to drug testing, the research didn't bear that out. You should continue to drug test at least 2 times a week throughout the course of all the phases. That was really interesting. That was not intuitive to me, and but for reading it in the standards, I wouldn't have necessarily known that. Super useful document. For our purposes in this solicitation, this document is also critical because BJA wants to see if you're proposing to enhance a particular service, such as your incentives and sanctions, or the treatment services that you're going to be providing, or the case management. They want you to indicate that you're familiar with this document. And so they want you to identify which standard correlates with what enhancement you're proposing. So you just need to open it up, familiarize yourself with these 10 and what their numbers are, and then indicate in your proposal, we're proposing to hire a case manager who's going to be providing, these warm handoffs and going to coordinate all of these services in a really holistic way. See Standard 6, complementary treatment and social services. Unallowable use of funds. There's a couple of different areas where BJA has identified different categories where you can't use funds. Anne referenced this in her question. There is a prohibition against using funds to serve violent offenders. This has been a prohibition since as long as I've been working with this solicitation. It's a congressional rider, so Congress has set this limitation on the funds, so it's kind of out of BJA's hands. However, there's an exception for veterans. Now, in the solicitation, they have the specific statute that identifies this, so this has the definition for what qualifies as a violent offense. Let me see if I can see what page it's on. Apologies, I don't see the page number in front of me, but we can pull it out for you once I find it. What's really interesting about it is that it identifies a crime that is punishable up to a year or more. We've been really curious about that definition because by our reading, unless you're exercising Tribal Law and Order Act enhanced sentencing jurisdiction, you inherently can't sentence someone to a, quote, violent offense under the federal definition. But keep in mind that this definition extends to any charge or conviction, whether it's state, federal, or tribal. So just something to keep in mind. This is a funding limitation. So there is nothing stopping you in your court from bifurcating your funds or having separate pools of money so that if you do want to serve violent offenders, that's a priority for you and your community, you still can. You just have to show that you're not using these funds to do that. So, and I do know of courts that do that and they do it well, so it's definitely an option. Other limitations that are pretty new this year, medication-assisted treatment injection sites. Greg, I'm hoping you could speak to this a little bit because I did not see a great definition in the solicitation, or at least I didn't see it, on what an injection site is. Is this intended for any type of place where MAT is provided, like any clinic, or is this more so narrow definition for some of those sites that we see open in like Philadelphia, where they're providing like a safe injection site for heroin that's not like buprenorphine or Suboxone or other types of like pharmaceutical opioids?
Yeah, you know what? This is new to our solicitation, and I want to make sure I quote the right information. So what I'll have to do is make sure I have to look up to make sure that I provide the right information related to that. So this is actually new that we have in our solicitation that is an unallowable use of funds. But give a correct answer, I want to kind of hold back before I say that, and maybe provide that through frequently asked questions. I'll be able to provide more details related to why that was added and what that means.
Thanks, Greg, because it is new. This is brand new. Otherwise,
Yeah.
this is really balanced against that BJA wants you to provide MAT, or at least not deny access to those of your participants that are currently using MAT. So real interesting. There's definitely a story there that we don't know, so that'll be interesting to see it play out. I have a feeling they mean that Philadelphia model of these specific safe injection sites, but I'm speculating. So others that you can see, these are related to incentives. Basically, you can't purchase golf cards or movie passes, those kinds of things with your funding. You can't buy vehicles, or I believe they mean you can't buy rides for your participants. However, they do make an exception for bus passes. But there's a really long, there's 2 paragraphs about how you can go about purchasing bus passes for your participants. It's a little bit complicated, not impossible, but worth looking at because it is very complicated. And finally, the exception that many of us know very well is no food or beverage, whether it's for your participants or for your team members, no food or drink. Very sad. Okay, so there's a couple overarching categories that they have applied to all applicants, implementation or enhancement. You have to show that that candidates promptly enter the drug court. What's really interesting about here is that I'm pretty sure that I've never seen this take place at a tribe. However, there are some courts out there that before somebody could be eligible to be in their drug court, they had to serve a mandatory minimum sentence. So you're their perfect high-risk, high-need candidate. Clearly, substance abuse is related to your criminal activity. Nevertheless, you have to go to jail first. That was just written into their statute. And so that's still okay here. Statutory requirements are what they are. BJA doesn't encourage them. So if this is part of your tribe, that's okay. You can still apply to this grant. But if you have the discretion, then don't do it. All the research shows the sooner we can get somebody into treatment, especially after a triggering event like an arrest or a conviction, the better. And so having someone sort of wait in time out in jail takes a lot of that opportunity for behavior modification, not to mention treatment, away. Some jails have really excellent treatment providers within the jail, but many do not. You must show that the proposed program will include treatment and services to address opioid abuse reduction. We mentioned that. And as I mentioned, despite that restriction on MAT injection sites, you can't deny someone because of their use of MAT. This grant has a match requirement. So it can be cash or in kind. Of the few peer reviews that I have seen, 100% of the matches were in kind, or effectively saying our judge will be on this project, 20% of their time, and so they're going to be using their salary, from another source as an in-kind match. That's mostly how they do it. Note that the match does not go to the total amount of money that you're requesting under the solicitation. So I use this example that if you were going to go for the whole taco, $500,000 that you can apply for up to this grant, well, then that only reflects 75% of your total budget because there's this 25% match. So if you were going to do that, well, then you need to come up with a $166,000 match because that reflects 25% of what would be your total budget of $666,000. Be cautious. BJA, if they award you your proposal, they're going to hold you to whatever match you provide. So if you propose a match that's in excess of 25%, they're going to hold you to it. So just be careful. Maybe don't do that. Go just for the 25%. Here's that citation. I put it in here. I didn't even know I did that. For the violent offender prohibition. It's at 34 USC section 10613. If you're holding the solicitation in front of you, it's on page 5. So you'll see it's a multi-part definition, 2 parts, and then a couple subparts. Basically, I think the takeaway is that it's a very serious violent offense, but it's for those that have been convicted or charged. So in that case, it's pretty broad. A candidate need only be charged with the violent offense to be ineligible under this definition, which is kind of crazy. I mentioned that there's an open question about whether any charge or conviction under a tribe could qualify. I don't think it does, but there is no case law to support that, so it's merely me speculating. Also note, for those of you that are putting your CTAS applications together, CTAS Purpose Area 3, where most tribes apply for their wellness court money, that is a separate pool of money. It's not drug court money, and so it doesn't have this limitation like the adult drug court does. Also note that veterans treatment courts have a special call out. They have been exempted, or at least type B, they have type A and type B. They've been exempted from this violent offender prohibition. Congress has at least recognized for veterans, which hopefully is opening the door for all drug courts, that this violent offender prohibition systematically cuts out the truly high-risk, high-need population. So they've made an exception. If you are interested in serving veterans, I highly recommend you look at this particular category. Because this is a new category as of last year, I don't think they get a lot of applications. And so it's really ripe if this is something you're interested in. Okay, we're going to briefly go through the application components, but I definitely wanted to provide this slide just to give you an idea of what's there. It is extremely similar to years in the past. So if you'd applied to this solicitation before, you're good. I also mentioned, I think it's much easier than CTAS. They really lay it out for you here. They give you an extremely detailed outline where you can just fill in the blank spaces. I highly recommend you do that. You'll note here the different percentages. They used to differentiate between the implementation and enhancement, which sections were weighted how. They've gotten rid of that. They're all the same now. 20% for your statement of the problem. The bulk of your percentage is in your program design and implementation, which is 40%, and then your standard capabilities and competencies and data plan. Those are all there. Your budget's only 5%, but it's hard to overstate how important your budget is. I've put in bold here, they require a time task plan. This is weighted as part of your program narrative. I believe it's part of your program design and implementation weight. So if you don't include a time task plan, it goes against your percentage. And they note here, they specifically want you to indicate the number of participants served each quarter. So it's, I think some applicants, no one on this webinar, have been guilty of phoning it in a little bit with the time task plan. They put a little bit more detail in what they want here. So I think it's time to spend a little bit extra time on your time task plan. They want a memorandum of understanding between the key team members. This is a really important document. I know lots of peer reviewers look for this. This goes towards your capabilities and competencies section. And really what it's indicating is that grant writer, you've put together a beautiful narrative. We definitely take you at your word. But here's a document just to show that you're not making it up. In fact, all of these brilliant team members that we referenced in this narrative have, in fact, expressed a commitment to this Healing to Wellness Court, as evidenced by this MOU. And finally, they want to see your policies and procedures manual. This is only for enhancement grantees, right? Implementation, you haven't started yet, so you don't have a policies and procedures. But if you do have something, or even if you only have a draft or some other documents that you've put together, it wouldn't hurt to upload them. I don't recommend that you flood your application with numerous different attachments. It's likely that the peer reviewers won't even open them because they won't have time. There's different strategies about whether you want to put all of these documents into a single PDF or have them as separate. I leave that to you. But if you do have some documents showing some of the good work that you've done, as long as it's reasonable, right? You can imagine a person with limited time thumbing through. This might be a good opportunity to further show the work that you've done that you just didn't have space to show in your narrative.
Hey, Lauren, this is Greg. I just want to add two other things on that last slide.
Here you go.
Okay. Yeah, the first thing for the program abstract from last year to, from the previous year to last year, if I'm saying that correctly, the program abstract was only 400 words. We increased it to 800 words just because we felt that wasn't enough. But one of the things that we see that was a challenge, we have a program abstract template, but sometimes individuals, when they were filling out that abstract, it wasn't enough words for them because I think the abstract or the template only provided maybe 400 to 600 words. So what you can do is be able to add or make an attachment if you have over 400 words or more, because it allows you up to 800 in total that we want to limit you to for the program abstract. But the template we have only allows, I believe, no more than 400 words. So if you see that you're going to go over 400 words, you can also do an attachment. And then the other thing I want to bring to your attention on there is you go to the solicitation on page 14 at the bottom. It talks about also what Lauren had talked about, what are the critical elements of your application. And there you'll see the program abstract, the program narrative, the budget detail worksheet and budget narrative, time and task plan, and if applicable, a fiscal agent memorandum. Those are things that you need to have in those applications. I've seen in past years where the time and task plan wasn't there, and it's one of the critical elements. That application just wasn't seen. So be sure to you have the critical elements within that application, and that's it.
That's a really great point, Greg. So they get a lot of applications, and so they'll use things like, do you have all the critical components? If not, well, we're not going to advance your proposal to the next level because we just need to start cutting the proposal somehow. And so that's a great way to get your proposal thrown in the trash just because you didn't have all of the components. So even if you don't love your time task plan, it's not your best work, that's okay. So upload something.
Yep,
so I was flipping through some of the sides to support some of your points, Greg, so we'll just kind of go over them a little bit. As he mentioned, they expanded the word count for the abstract to 800 words, which is great. I still don't think that's enough. Look at all of these things that they want you to put in your abstract. It's crazy, Greg. They have so much stuff in here.
Yeah.
So good luck. Just note, it's just an abstract. This abstract doesn't go to your page count. It's also not part of the percentage. It's sort of one of those things that they want you to see. It's a helpful document, especially for peer reviewers, to sort of get a snapshot of who you are and what's in your proposal. So don't sweat it too much, but do make sure they ask for a lot of things, and you want to make sure that you address each one. The peer reviewers are given a checklist where they literally check off whether or not you included each component. And so even if you're only able to say a few words, make sure you address each component. So we got a couple of really good questions. So I'm going to pivot over to our questions box for a minute. We got a question regarding the funds, those contract and compact funds. Yes, those funds can be used for a match. This was the first year in the solicitation where I saw a clarification that in fact can be used. That's interesting because those funds are technically, right, those are federal money, but nevertheless, they can be used for this, quote, non-federal match, which is super cool. Yes, the Policies and Procedures Manual is only for enhancement grantees, but as I noted, if you had anything else for your implementation grant that you wanted to include, you can. And then finally, Chanel asks, if we have an operational drug court but have only been implementing the project for around 9 months, do you suggest going for an implementation? Ooh, that's a good question. Greg, if they've been operating for 9 months as of drafting the proposal, should they go for enhancement or for implementation?
Well, for enhancement, you would have them operate, you have, based off the application, the date is September 30th, 2019. So if you're going to be in operation at the point of September 30th, 2019, then you would be applying for enhancement. If it's before September 30th, 2019, then you would be applying under implementation.
Okay, that's helpful. So September 2019 is our date. So if you will have been operating for a year as of next September, then the enhancement grant is for you. And frankly, that's what I would recommend too, just because you will have been operating, you'll have, hearings and staffings under your belt. You're ready to sort of pivot, now that we've been doing this for a while, what do we see that we need to change versus an implementation grantee, no hearings or staffings under their belt, just getting started. So here's the program narrative. As I mentioned, these different sections, these have been the same different sections that we've seen for a while. They're also very similar to CTAS. So for our grant writers on the webinar, this should hopefully be familiar. We're just gonna run through it real quick. I'm not gonna spend too much time on these slides because a lot of them are verbatim from the solicitation. I just wanted to pull it out so that you can see it. What I've done here is this is just a snapshot from page, what is it? It's from page, oh, I thought I had it, but it's from the solicitation. And what I'm trying to show is that this is your checklist. When you're putting your solicitations together, these are the different questions that you need to answer. So this is from page 33, and it's in regards to the statement of the problem. So you see category 1, implementation, there are 4 different sections that you need to address. So whether you have subheaders or you organize it by different paragraphs, whatever, your peer reviewer is going to have 4 checkboxes. Do you have these 4 sections? If you're an enhancement applicant, well, you have a couple of different sections. So there's these 2 primary bullets, but then you'll notice all of these yellow sub-bullets. Same thing, your peer reviewer has a checkbox for each one of these. So they're going to be looking like, okay, did you talk about referral? Great. Did you talk about eligibility requirements? Great. What about target population? I'll be honest, it doesn't make for the most smooth read that you've ever had, but I highly recommend that you organize your narrative with these subheadings because that's what your peer reviewer is going to be looking for. There might be instances where you find yourself repeating something or duplicating something that was earlier in the narrative. That's okay. You want to address each of these categories. So here's those categories sort of pulled out for the statement of the problem implementation. Because you're just starting, right, you can't talk about your wellness court that doesn't yet exist. So they want to know what's the background for your community. What, if any, data do you have to indicate the substance abuse and criminal justice issues in your community? I highly recommend that if possible, you talk to your tribal court and to any and all substance treatment providers in your community to get hard numbers of what's in there. Anecdotal stories are perfectly welcome. They often provide a really powerful read, but if you don't supplement that with data from your systems, you're going to get marked down, just hands down. Now, it's perfectly reasonable that you don't have access to that data for whatever reason. Maybe the community members have access to a wide variety of treatment providers, both IHS as well as private, and they just aren't yet willing to share that data with you. Maybe, you have tribal court data, but you know that only represents a fraction of the crime being committed in your community because either you're in a PL 280 state or you know that a lot of crime is being committed off reservation, and so you know that your neighboring jurisdiction has access to a lot of that data that provides a much clearer picture. That's okay. You can indicate that in your narrative, but you just need to show that you have a sense of what's going on and you either have the data or you know where it is, you just don't have access to it yet. Also note, they want to see your capacity goal. How many participants do you anticipate being able to serve? And they need a hard number here. On average, I would say wellness courts operate between the 10 to 25 range. With, of course, like a wide variety there. Some courts have an average of 5 participants. I know we're working with one wellness court right now that has 54 participants, so there's a wide variety. Enhancement grantees, they want you to, in detail, tell us about your wellness court. It looks tough. They've got all of these different categories, but like I said, I think it's actually much easier because they just lay out everything that you need to highlight. So you just can go by it, one little item at a time. Easy peasy. Similarly, they want you to describe your wellness court, describe the issues that you are looking to address. As I mentioned, we want to see a connection between your statement of the problem and your proposed enhancement. Program design, these are the same issues that I identified earlier that they want to see all of our applicants address. And I apologize, I'm going to flip through these as we're nearing the end of our hour. I want to make sure we have time to address some of your questions. But also, this is all spelled out in the application. I just wanted to make sure that you all had access to see it. These categories are exactly the same that the enhancement grantees had to talk about in the statement of the problem. Implementation, your turn, talk about what you want your wellness court to look like, one item at a time. We also want to see, ding, 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 what NADCP standards are you going to be using? And they have a number of different questions about how you're going to be ensuring fidelity to the wellness court model. These are areas where you might find yourself repeating yourself or duplicating things that you already talked about. That's okay. You just say again, as I noted in the target population and eligibility area, we're going to be targeting high-risk, high-need offenders with this assessment tool. Enhancement. Here's where it gets a little bit open-ended, and so it's up to you, applicant, to detail what your proposed enhancements are. It's not required in this solicitation that you have specific objectives and deliverables, but for those of you that are comfortable in that arena with grant writing, identifying, we have, 2 goals with one, objective each, that's a great way to organize it. A lot of people are familiar with that. It's also a great way to connect this section to your time task plan. But if you're not comfortable with that sort of compartmentalized thinking about your different objectives, that's okay. However you want to organize it, that's going to be very, clear and connected to your time task plan, it's up to you. But you don't have a whole lot of space because they have a whole bunch of other stuff that they want you to address in this section. Capabilities and competencies. This is a really important section, but it's also detailed out in these different categories they want to see. Here's where they're going to check if you have your memorandum of understanding. They want to see communication and coordination strategies. There's no special answer that they're looking for here, but what it is a recognition of is that communication is frequently a hang-up for applicants and for any operational wellness court, frankly. Lots of people struggle with confidentiality, professional ethics, as well as just the day-to-day communication about really tough participants. So both from like a technical confidentiality standpoint and also just from a be nice to your neighbor standpoint, what strategies are you going to have? They want to see who your team members are. They have a specific call out for law enforcement and probation, which I think is interesting. And here they also have a specific call out for treatment, and that's because treatment varies pretty widely across jurisdictions. Really similar for enhancement, almost identical. Data collection, they want to see your evaluation plan. How, if at all, are you going to plan for formal evaluations? Here was a new one. They wanted a process for how you are going to review the number of participants you're serving each quarter. I hadn't seen that before, and so that's where they wanted to see that in your time task plan. So that's kind of interesting. They're really sort of putting some meat on the bones for how you're reviewing your data. Really similar to enhancement. They have some different URLs for performance measures. I've actually found these to be really useful. You don't need to detail them in heavy detail in your narrative. You really just need to indicate that you're aware of the performance measures and then call out some specific performance measures that you'll be using. But really, they just want you to indicate an awareness that you know of these tools and have looked at them. So I'll flip through these. This is the National Drug Court Resource Center. They've got a lot of different stuff on performance measures as well as just other drug court documents in general. So I wanted to make sure you were aware of them. Evidence-based programs. So these are magic words. These are in reference to specific services that have been, quote, proven effective or are evidence-based. As I indicated at the beginning of the webinar, this doesn't include proven effective in your specific community, which is particularly relevant for tribal communities. Nevertheless, I think it's good to familiarize yourself with these and be aware that if you are going to use one of these programs, great. If you're not, why not? Either way, you indicate a familiarity that these programs exist. Lots of tribes have really like different programs. I know lots of tribes use motivational interviewing. Moral recognition therapy is extremely popular. There are other programs that tribes have been using that are tribal specific, such as the parenting services, positive Indian parenting, fatherhood and motherhood is sacred. There are other evidence-based programs that tribes have used but have made a tribal adaptation for. And I think there's really promising areas in that arena as well. All of that is to say, we highly encourage that you have some kind of strategy for what services either your treatment provider will be providing or that the wellness court is going to be providing in addition to what the treatment provider is using. Some common mistakes with putting your grant together. I can't say it enough, not responding to all of the requested information. The challenge, just like any federal grant solicitation, is they ask for 35 pages worth of information, but only give you 20 pages to do it. There's a lot to squeeze in, but it's critical that you address each question. So even if you feel like you weren't able to fully answer a question, it's important to cut it off so that you can get to the next one. Failed to draw a connection between the statement of the problem and the program design. You said that this was your problem, but you proposed B. I don't get the connection. Why should we give you funding if it doesn't seem like you need it? Not providing the requested information in a relevant section. You might note, and a lot of applicants do this, that, well, you wanted me to describe my Healing to Wellness Court in my program design because I'm only an implementation grantee, but I want to talk about it in my statement of the problem because that, I have some great reason. You might have written a beautiful grant and it frankly reads better, is smooth, and you've made this holistic, beautiful story. But if it's in the wrong section, they're going to mark you down. And that's a really crummy way to get your proposal written down. So even though it might look clunky and just read not nearly as well, I highly encourage that you follow the format that they laid out in the solicitation. Failed to draw a connection between the proposed budget and the programmatic activities. I know a lot of peer reviewers that when they open your application, the first thing they go to is your budget. What does your budget say that you're going to be spending money on? Great. I'm going to use that as my lens for when I'm reading your statement of the problem and program design. You said you wanted money for drug testing kits. Have you identified drug testing kits as a need in your proposal? Sometimes there's just a huge disparity between what the narrative says and what the budget says. And it's not crazy. Those are usually two different individuals that are putting those documents together. So it's important before you hit the submit button that those two people talk to each other. Similarly, there's inconsistencies within the proposal. Different people were putting different sections together. That's just the nature of a team-based approach, which is really great, but just make sure that you have someone go through it at the end to make sure that all of the different sections are addressed, but are also consistent with each other. And finally, did not provide specific measurable targets for your performance measures. This is especially relevant when it comes to the number of participants you're proposing to serve. They want to see a number for both implementation and enhancement. Implementation, how many do you plan to serve? Enhancement, how many people do you plan to serve in addition to who you're serving now? Tips. Check all of the resources linked in the RFP. There's lots of hidden ones. I've identified many of them, but not all. They're all linked, and so that's a great, so whether you're pulling it up as the handout here or online, you should be able to access those URLs. Use the scoring criteria as a guide for page numbers. I think that's a really useful tool. Your program design is 40% of your score, so it might stand to reason that it should be 40% of your page numbers. Don't wait until the deadline to apply. I say this with a grain of salt because everybody waits till the deadline to apply. But by this, we really mean don't wait until midnight or 9 p.m. Eastern. The website gets flooded because everybody's doing that. And there have been a number of tragic stories of applicants that were not able to upload their document because the website crashed or it just timed out. Don't let that be you. Give yourself at least a couple hours to allow for the website to do its thing. As I mentioned, go back and review the budget after completing the narrative. We want to make sure those two documents are telling the same story. Don't forget about your other attachments. In addition to the time task plan and the MOU and the policies and procedures, there's a number of other technical attachments that they want to see, including a tribal resolution that basically shows that tribal leadership is aware that you're applying for this grant and that you're doing so on behalf of the tribe. Other things like your indirect cost agreement, things like that. So make sure you upload everything that you need to upload. And we recommend that you PDF everything. The grant management system allows both PDFs and Word documents. Again, no one on this webinar, but I've seen sneaky applicants upload Word documents attempting to get around the page limitation by using legal size paper instead of letter. Unfortunately, what happens for them is that it cuts off when you print. So whatever was at the 20-page limit for your letter size is what the reviewer saw, which definitely defeats the purpose. But also formatting gets really weird. Just between uploading it to the system and then downloading it, things get messed up, and you're less likely to be a victim of that if you PDF. So I think that's your best bet. If you're unsuccessful, you have a right to see the comments that peer reviewers make on your proposal. I have found this to be incredibly useful. It gives an insight on what they're seeing from your proposal and what they would have liked to see. This is true even if you are successful, but certainly if you're not, ask to see your peer review comments. Consider serving as a peer reviewer. That's a great opportunity to, read 10 different versions of an application and see what comes across as really good. There's also lots of resources out there to assist you, both in the meta level of your Healing to Wellness course generally, but also on your specific grant writing, so feel free to reach out. Okay, real quick, just to put them on your radar, Greg, do you know if COPE will be coming out this year?
Yes, it will be coming out. They made a couple adjustments to it in terms of categories, but yes, it should be coming out within the next maybe 3 to 4 weeks, I believe, that the solicitation will be released.
Okay. Keep this on your radar, everybody. This is a really brand new program as of 2 years. It has a ton of money and not a whole lot of applications. I listed categories 1, 3, and 6 because these are the ones that tribes were eligible for last year. It sounds like they might be reorganizing it, so it could look a little bit different. This is basically for everything except healing to wellness courts, but you can use this to fund services related to your healing to wellness court. So lots of opportunities here. CTAS, of course, has funding usually under purposes areas 3 and 8. I note here CTAS is a coordinated solicitation between lots of different Department of Justice agencies. It's tribal-specific grants, but it's not all of the tribal-specific grants, as you can see here. I'll skip our pros and cons, but you can see here the purpose areas. For those of you that applied this year, you'll note there was a new purpose area this year, purpose area 10, which was very fun. And I'll just put this here briefly just to show the competitive nature of the different purpose areas. Purpose area 3 is a really popular one for healing to wellness courts, but it's extremely competitive. Only 30% of applicants were funded. Purpose area 8 is specific to juvenile healing to wellness courts. And as you can see, very few tribes apply for it. And of those that do apply, they get funded. 75% received a grant. So if you were considering a juvenile healing to wellness court, there you go. Also, just wanted to briefly point out that purpose area 5 is extremely non-competitive. 95% of applicants get a grant. So just want to point that out there. This is the funding levels for purpose area 3. It's been pretty consistent. We're up to 21 million. It started at 26 million in 2010, so that's pretty good. Juvenile healing to wellness courts, not very much money, only 2.7 million. Okay, so other solicitations I just want on your radar. This is Office for Juvenile Justice and Delinquency Prevention. This was released last year. I'm hoping that they will be releasing it this year. However, unlike BJA, Adult Drug Court, this has been a very consistent solicitation. Every year it comes out, you can count on it. This one, not so much. I'm really hoping they'll do it this year, but it's been really inconsistent. Last year, they had a specific grant for juvenile drug courts. Tribes are eligible for this, even though it pretty much mirrors CTAS Purpose Area 8. That's okay. If you want to apply for both, you can. They also had a family drug court grant. This was the only solicitation I saw that was specific to family healing to wellness courts. So those are wellness courts that are serving a dependency docket targeting parents whose children have been removed. A really neat solicitation. 3 tribes were funded in fiscal year 2016. Pretty cool. I'm hoping to see it again. SAMHSA has some solicitations. These unfortunately have closed. They closed back in January. However, when they closed, they opened it up again because nobody applied, or not very many people applied. So I want you to put this on your radar for next year because they really, really want tribes to apply. These grants are specifically for treatment services, but they target drug courts and healing to wellness courts. So if you're looking to build up your treatment capacity, expand your services, start a new program, build a residential treatment center, whatever, lots of opportunities here. Notice they're also really flexible with how they interpret recovery services, including things like housing and childcare. Lots of opportunities. I note here last year, 2 different tribes were funded, so it is possible. Saginaw, Chippewa, and Penobscot each got one of these grants, which is pretty cool. Wellness court resources. We will be having our enhancement training. Mark your calendars, September 10th through 12th. You are the first individuals we are announcing our save the date for, so very exciting. For those of you that are familiar with this training, you know that we have been holding it in Albuquerque for the last couple of years. We are changing locations this year. We'll be in Palm Springs, California, and that's primarily due to the fact that we outgrew Albuquerque. We anticipate around 350 attendees. This is all tribal specific, all Healing to Wellness Court. We'll be having a track on juvenile wellness courts, on veterans treatment courts. There's going to be all sorts of good stuff here. It's free. We warmly invite you. And on this website, this is enhancementtraining.org. You can see all of the training materials from last year. All of the PowerPoints are still posted, so you can get an idea of the types of trainings that you can anticipate. Here are some other trainings that we're going to be at. We'll be at Michigan, at Arizona. We'll be putting on a veteran-specific training in June, so stay tuned for details on that. We'll also be at NICWA in Albuquerque, so that'll be fun. And finally, hopefully all of you are familiar with the NADCP conference, the National Association of Drug Court Professionals. This is the National Drug Court Conference. It includes tribes, but it's also states, counties, municipalities, and everyone in between. Huge conference. I think they have like 2,500 people there. It's going to be in DC. It's a really, really great conference, especially if you have team members that are new to the wellness court field. There's something for everybody here. This is not a free training. It has a cost. However, this is a training that you can apply for funding for under the solicitation. So in your application, make sure to include a funding category to go to something like NADCP. On our website, you can find our publications. These are all good links that you can access on your PDF. All of our publications are free and you can download them anytime. But if you're the kind of person that likes a hard copy, I totally get that. We have a budget to print copies and ship them to you, so just let us know and we'll ship you whatever you want. And finally, we are very vested in expanding tribe capacities to serve veterans. We're partnering with the Justice for Vets. So I mentioned we'll be doing that training in June. We also have funding to provide individualized technical assistance in this arena. So if this is an area that is interesting for you, please let us know. We'd love to help. And here is our contact information. And with this, I'm going to shift over to our questions and answers. If you have any questions, please feel free to type them in the little box. Would like the slide of wellness court trainings to include in our grant application. You should have that in your PDF, in your handouts, but I'll flip over back to that slide for you so you can see it. Hopefully this is the one you mean. If you have any other questions, please feel free to type them in. In the meantime, I don't see any, so Greg, do you have any closing thoughts you'd like to end us with?
Yeah, I'd just like to appreciate everybody getting a chance to come on and participate in today's webinar, and I really, really look forward to your applications. Again, this is a priority of our administration to ensure that we do the best job that we can to provide access to services for tribes. So we look forward to your applications, and thank you for being a part of today's webinar.
Well, with that, you can always email me at any time. I'll go back to my email, wellness@tlpi.org. Anytime. You can also call our office. I wish you the best of luck in putting your application together. Who do we request past successful applications from? Greg, can we do that with you?
Yes, so yeah, you can just contact me if you submitted an application last year and you want to find out based off all the questions that you completed. I'll be able to get you that information. You just have to give me your application number. And if you can submit that to me via my email, the gregory.terrain email, and I would work towards getting that information for you.
Can they request that even if they don't have a grant number?
they can send me an email. I have to be able, if they submitted an application last year and wasn't awarded, I probably could find it.
So they're asking if they can see a different tribe's successful grant.
We do have ones on the NDCR, the National Drug Court Resource Center website. I don't know if we have any successful tribal ones listed, tribal wellness courts listed on there. What I can do is look to see out of the ones that we had successful. I could have it. I can have it didactic where they would be able to not necessarily see who the application or who the grantee was, but I can do that. It may take me about a week or so, but I can have that information on the National Drug Court Resource Center, or as well as on TLPI's website, be it provide.
Oh yeah, we would love to post that. But Shanil, I recommend emailing Greg. Another option is that on the BJA website, you can see a list by year of who successfully received a grant, and you could contact a specific tribe to request it just on a one-to-one basis if they would be willing to share their proposal with you. However, because this solicitation is pretty regimented, it's very, standard for both tribes and non-tribes, I think it'd be helpful just to see any successful application, whether it was tribal or non-tribal. So I recommend, following up with Greg to get the redacted tribal one, but also just looking at the standard successful grant application, it would be really helpful. For CTAS, I think it's less helpful because they're so varied, but for this grant, it's helpful.
Yeah, and where you can go to see those, I think we have maybe 4 or 5 of them already on the National Drug Court Resource Center website. So if you go under www.ndcrc.org, and then from that, on the left-hand side, the tab, you'll see it says resources. You click resources. The drop-down menu will say grant solicitation resources. And from that, you'll see where we have some of the successful applications listed that you could download and review.
Awesome.
Yep.
Okay. Well, I appreciate everyone staying on for a few minutes past our allotted end time. I tip my hat to all of you. Putting these grants together is extremely hard work in addition to your full-time jobs. So if I can be of assistance in any way, please contact us, and best of luck. And with that, I will let you all go. Have a great afternoon. And Greg, thank you so much for joining us.
Yeah, thank you, Laura. Appreciate it.
All right. Take care, everyone.